Hi friends, good evening and welcome everyone for today's session, continuing with our series of Supreme Court case law. So again, a peculiar case law and given or ruling given by the Honorable Supreme Court. The case law is relating to automatic vacation of stay granted by tribunal. It was a case of Pepsi Foods Limited. Before starting the session, would like to acknowledge the efforts of Deepika and Gracelyn for preparing this PPT. The legends used pretty much similar to what we have seen before, friends. Presentation schema, the background overview of the legal provision under challenge, facts of the case, what were the contentions of revenue as well as the assessee, constitutional validity of the third provider to section 254(2)(a. What it is, we'll dwell into it later, and this is what is the provision under challenge in the Supreme Court. What was the Supreme Court's verdict and the conclusion? So let's get started, friends. The background and overview of legal provisions. Yes, taxpayers have a right to of appeal against the orders passed by income tax authorities under the Income Tax Act. So whatever order passed by assessing officer, it can be appealed to CIT appeals, then further to ITAT, High Court, and Supreme Court. Appellate authorities, while deciding on the appeals, have inherent power of granting stay against the tax demand raised by the income tax officer. Say, for example, an assessing officer is passing an order which has an addition of some amount that which has resulted into a tax liability of say 50 lakh rupees. So 50 lakhs, while appealing to CITs or rather say the ITAT, there needs to be not CIT appeals but ITAT, when there needs to be a payment of some of a sum of that tax amount or a percentage of that tax amount. However, the appellate authorities have the power to grant stay against such tax demands. This power to grant stay has been subject to numerous litigations because, again, as I said, it is subjective and it depends again on the ITAT as to how much amount or how much percentage the stay should be granted or whether the stay should be granted or not. Thus, there has been a tussle between the judiciary and the tax tribunal's power to grant a stay on demands raised by the revenue department, and this is what is the moot point of the entire ruling, which we'll be discussing today. Overview of section 254. 254.1 deals with the power of appellate tribunal to pass any order after giving both parties an opportunity of being heard. 254.2 deals with power of tribunal to amend the order passed under section 254.1, and the 254.2a. In every appeal, the appellate tribunal has to dispose an appeal within a period of 4 years. It gives a timeline as to in how many years the appeal needs to be disposed of. Now, there are various provisos under section 254.2a. The first proviso, it says the tribunal will have the power to pass an order of stay in any proceedings. The period of stay, the initial period of stay would be 180 days. However, it can be extended to another 365 days, that is another 1 year by an application made by an assessee. So extension of 1 more year is given in proviso 2, and proviso 3, which says that there shall be automatic vacation of stay order after a period of 365 days, even if the delay is not attributable to the assessee. So what proviso 3 says is, after an extension of 365 days, so 180 days plus 365 days, once that period has been passed, the stay which has been granted, that there shall be automatic vacation of stay, even if the delay is not, even there is no delay attributable to the assessee, still there would be automatic vacation of stay. So now this is the background of the legal provision which is under challenge. Now let us see the facts of the case in the given ruling. Assessee is a respondent. So High Court assessee has won the appeal at High Court, to which Revenue has preferred an appeal to the Supreme Court, and assessee is the respondent. It's a Pepsi Food Limited is engaged in the manufacture and sale of concentrates, fruit juices, processing of rice, and trading of goods for exports. What are the sequence of events, friends? Assessment order for AY 89 was passed favoring Revenue. Assessee was agreed. Assessee approaches ITAT appealing the additions order passed by AO. ITAT granted stay on the assessment order in May 2013. Stay was further extended till May 2014. So stay was initially granted and further it was extended until May 2014. Efforts to secure a further extension on the stay order failed owing to third proviso to section 254(2)(a). So after May 2014, Assessee tried for further extension of stay as there was no delay attributable from his end. There was delay from revenue's end. So here further efforts were put in by Assessee, but he could not get further stay after May 2014 because of third proviso of 254(2)(a). Assessee files a writ petition before the Honorable High Court challenging the constitutional validity of third proviso. So here the question, the moot question is the constitutional validity of third proviso, which says that there would be automatic vacation of stay after the extended period of 365 days, even though the delay is not attributable to the assessee. So whether that is a right provision altogether or it is constitutionally invalid. So for that reason, assessee has preferred an appeal in the High Court. High Court was with assessee's view and it granted or it stated that the third proviso is violated, third proviso to section 254(2)(a) is violative of Article 14, which is rights to equality of Constitution of India. So it is violating Article 14 of Constitution of India because the delay is not being attributable on the part of assessee and still the stay gets automatically vacated. So now the case is lying in the Supreme Court. So let's see now what were the various contentions of assessee and revenue before Supreme Court. So first is whether provisions of tax statutes can be challenged under Article 14. So this is the first question. What was revenue's contention? Revenue said that when Article 14 is applied to tax legislation, greater freedom must be allowed by the court in judging the constitutional validity of the same. As long as the state has laid down a valid policy which it has followed without singling out anybody, no discrimination can possibly ensue. Thus, the test of Article 14 is to be used sparingly by courts while testing the constitutionality of the tax statutes. So this was the contention of revenue. What was assessee's contention? Discriminatory taxation can be struck down under Article 14 of the Constitution. State cannot take shelter under a policy if the policy or object laid down in the statutory provision is itself is arbitrary or discriminatory. So what assessee's contention was, the third proviso to section 254(2)(a) is discriminatory in nature, number one, is arbitrary in nature, number two. So if these are the element present in any section, that is wrong or that is violating the Article 14, which is giving a right to equality to everyone. So it is violating Article 14 of Constitution of India. Whether assessee has an inherent right to obtain stay. So this was again a second question, to which revenue's contention was there is no inherent right of assessee to obtain a stay. So what revenue contended, it depends or it is at the discretion of the appellate court to grant stay or not. It again depends on the person who is there in the appellate court whether to grant stay to a particular assessee or not. That is what revenue's contention was. To that, what assessee or what was the argument of assessee? Assessee's right to appeal inherently include rights to obtain a stay. So what assessee contended, like if there is a right of appeal available, automatically right to obtain a stay is also available. One cannot be denied, or rather once such stay is obtained, it cannot be vacated without a default committed on part of the appellant. So what was the contention of assessee? If there is a right to appeal, there is a right to stay as well, and once that stay has been obtained, it cannot be vacated unless and until there is some unlawful or some malintentions from the assessee's perspective. So this was the contention of assessee and revenue. Now, constitutional validity of third proviso to section 254(2)(a). So on those two grounds, we saw the contentions of revenue as well as assessee. Now let us confirm the constitutional validity of this proviso itself. Article 14 in context of statute. So what Article 14 provides? The right to equality and equal protection of laws. The fundamental principle which is enshrined in Article 14 is equals must be treated equally and unequals must be treated unequally. A taxing statute, that is any tax provision, may contravene Article 14 if it leads to obvious inequality. So what court said is, if any provision, if at all it is unequal, so it is it is the interpretation is something else for one person and something else for another person, that is inequality. Secondly, what the Supreme Court said is, if any statute, if it has element of discrimination, number one, and manifest arbitrariness, if any statute has these two provisions, or rather these two elements in its provision, or rather in that particular section, then that section is unlawful, number one, and it is not equal for everyone, number two, and it may be constitutionally invalid. So now let us see whether the third proviso to section 254(2)(a), whether it is discriminating in nature, number one, or it is arbitrary in nature, number two. First, the test of discrimination. The second proviso, if you see, friends, it says the disposal of appeal by ITAT within 365 days is directory, as it uses the word may. So now, if you see the second proviso, which provides the extended 365 days of granting of stay after 180 days, it says that the ITAT may dispose of an appeal within 365 days. So here the words which is used is may and not shall. So again, it would be at the discretion of ITAT whether to dispose of or not. So the second proviso uses the word may. However, if you see the third proviso, friends, it uses the word shall. So what does it say? It's like after 365 days, if there is no appeal which is being disposed of, then there would be automatic, certainly there would be automatic vacation of stay. Here again, the word which I use is shall and not may. Friends, if you see, again, same section but two provisos, but in one proviso the words used are may, which is again kind of giving a discretionary power to the appellate tribunal. And in the third proviso, that is the another proviso, which is third proviso, which is talking of vacation of stay, that is an obvious section or obvious provision, which is saying that yes, it has to be vacated. The stay has to be vacated after the extended period of 365 days. So court finds that the third proviso is discriminatory. Basis this ground, it is discriminatory and hence violates Article 14. So third proviso to section 254(2)(a) does not stand the test of discrimination. Hence it is violating Article 14. And now let us see whether it tests the validity of manifest arbitrariness. Court finds that the third proviso to section 254(2)(a), which provides for vacation of stay in favor of revenue, even if the revenue itself is responsible for causing delay in hearing the appeal. So what are the exact wordings of the friends of third proviso? It says that there will be automatic vacation of stay even if the delay is attributable, or rather delay is not attributable on the part of assessee. So what does it mean, friends? If there is a delay from department's ends as well for disposing of or rather disposing of appeal, in such a scenario as well, there would be automatic vacation of stay. Now this seems to be unjust or unreasonable for assessee, because there may be some tactics, some unjust actions or tactics which would be taken by the revenue to ensure that the delays, the appeal is not getting disposed of in that extended vacation, extended stay of 365 days. And once the 365 days has been like passed, automatically the stay gets revoked, and the assessee has to pay the amount of tax demand, whatever it is. So here, if, even though there would be delay from the revenues end, after the extended period of 365 days, the stay gets automatically vacated, even there is no nothing unlawful or nothing wrongdoing from the assessee's end as well. So while referring this, the Supreme Court referred the case again of its own jurisdiction, referred the case of Shaira Bano versus Union of India, 2017 case law, where it says that manifest arbitrariness therefore must be something done by the legislature capriciously, irrationally, and or without adequate determining principle. Also, when something is done which is excessive and disproportionate, such legislation would be manifestly arbitrary. So, while analyzing whether the third proviso is manifestly arbitrary or not, it referred this case law, and the precedence was given, or the rather the, uh, the precedence was available in this case law, the Shaira Bano case law, as to what or when the particular provision or section would be manifestly arbitrary. So now, if you see, friends, the third proviso to section 254(2)(a) did not test the validity of, I mean, or was not valid on terms of test of discrimination as well as on terms of test of manifestly arbitrary. So now, what was the verdict? Now, this being the case, it's the Supreme Court said that the third proviso to section 254(2)(a) is unconstitutional in nature, because it is saying that even though the delay is not attributable to assessee, the stay would get vacated. It read that the order of stay shall stand vacated after the expiry of the period only if the delay is disposing of the appeal is attributable to the assessee. So, while concluding its judgment, it says that it should be read as only if the delay is in disposing of appeal is attributable to the assessee. So, it's diverged its view from, or rather, diverged its wording from the actual wording which were available from the third proviso to section 254(2)(a). Hence, it was said that the third proviso to section 254(2)(a) is unconstitutional. Now, what is the conclusion or the key learnings which we understand from this particular case law, friends? The court affirms that tax policy must not be arbitrary. Number one. Second, automatic vacation of stay after 365 days cannot occur if there is no default from the part of the assessee. Again, it provides a welcome relief where there was, because if there is a delay attributable from the department's end, still the assessees had to face the brunt of vacation of stay. But now with this ruling, friends, these practices would stop. So it is noteworthy to mention that Honorable Supreme Court has given the ruling ignoring the aspect of literal interpretation. So one more key learning here is, friends, the aspect of literal interpretation, where the analyzing of section is always on the literal interpretation. The court here has taken a diverged view. It said that even though it is said the delay is being attributable to assess, not being attributable to assessee, still the vacation will be there. It has diverged and said like this is wrong. The section or the provider should read that only if there is a delay attributable to the assessee. Another learning, friends, a rationale can be extrapolated from the ruling that the fundamental rights cannot be denied if there is no misconduct from the assessee's end. So one more learning from this case law, friends, is that fundamental rights cannot be denied even though the literal interpretation says something, number one, or there is no misconduct from the assessee's end. These are the two important things. If these two important things are there, fundamental rights cannot be denied to any assessee. The way forward, as you have seen, friends, Finance Act 2020 has amended 254(2) and it has provided for more conditions and limitations to grant stay by the tribunal. For example, it has asked for 20% of the dues, or it is asking for any securities to grant stay. So it reflects. So what does it mean? That department, or rather the intent of legislation, is to curb the tribunal's unconditional power to grant stay. Even where there is assessing, where the assessee has established a prima facie case and is actually undergoing some genuine hardship. So with these amendments, which is there in Finance Act 2020, states the intention of legislature that yes, tribunal will not have unconditional or discretionary power to stay, but if at all there are some conditions or covenants being satisfied, then only this would be available. Further, basis this ruling, we might see some amendment in section 254 to it, rather than specifically in the proviso, the third proviso, maybe in the budget which will come in FA 2022. Further, this precedence which is provided in this ruling can be or may be used by the Assessee, various assessees, different assessees, where literal interpretation of tax provisions can be challenged for denial of fundamental rights. So, say for example, in some other section, friends, if a fundamental right is being denied only on account of literal interpretation of that particular tax provision or that section, the ruling or the precedents from this ruling can be or may be used by SSC. We would never know whether it would be 100% useful or not, but certainly this ruling has given precedence that, or rather the main principle that fundamental rights cannot be denied if there is no wrongdoing from SSC's end, and if literal interpretation uh, 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 provides an unjust treatment for the assessee. So these were some of the thoughts, friends, on the case law. Thank you, friends.